It's Friday, January 31st, 2025, and both the state and federal governments appear to be functioning.
It appears that all of the systems that have been cut off as a result of the memo freezing funding, that those systems are back online.
From Capitol News, Illinois, I'm Peter Hancock, and this is Capitol Cast. Hello and welcome to Capitol Cast, a regular podcast of Capitol News, Illinois. Illinois lawmakers were back in the State House briefly this week, but that was by no means the big story. On Wednesday, people in state government and throughout Illinois got up to find the flow of federal dollars into state coffers had largely been cut off. That was the result of a memo issued the night before by the Trump administration's Office of Management and Budget, directing all federal agencies to temporarily pause the distribution of grants, loans, and other financial assistance programs. Naturally, there was immediate confusion about how far that applied. State attorneys general, including Illinois AG Kwame Raoul, quickly went to federal court seeking an emergency injunction. And the White House tried to downplay it by insisting it would not apply to things like Medicaid, farm programs, small business loans, and other popular federal services. But Illinois Governor J.B. Pritzker wasn't buying it.
Donald Trump's administration is lying to you. The White House's attempt to walk back what they did today does not match what we saw on the ground. They assured us that Medicaid would not be affected. That was a lie.
By late afternoon, a federal judge in Washington, D.C. had issued an order blocking the freeze. Federal funds started flowing again, and the wheels of government were back on track, at least for the time being. But that experience certainly seemed to rattle people in Illinois and throughout the country. One of the people at CNI who helped cover those events on Wednesday was Ben Szalinski, who joins us here today. Ben, thanks for being here.
Thanks, Peter. Should be an interesting conversation.
Yeah, so I guess one thing that this taught us was really how reliant the state is on federal funds. You and I, we cover the budget process, and we often talk about the general revenue fund budget, which is how the state spends its own money. But there is a lot of federal money that flows through the state, too. How much are we talking about here?
It looks like we're talking about upwards of $21 billion when you combine stuff that's in the general revenue fund plus other long-term capital funding that the state receives. And this is a lot of money for all kinds of things. It funds a lot of Medicaid, half of Medicaid for Illinois residents. It funds new infrastructure projects that the state has a priority for. It funds things in K-12 schools. It touches every part of people's lives, essentially.
Okay, I guess the experience also kind of gave us all a refresher course in U.S. Constitution and civics education about who has the power of the purse. There was a lot of talk about whether or not the president was exceeding his authority there. In a nutshell, what does the Constitution tell us about who decides how spending goes?
Yeah, the Constitution's pretty clear that it's Congress that controls spending at the federal level. Congress passes the budgets, they pass the revenue plans, they pass the spending plans, and obviously it's the president who ultimately signs off on these sort of plans. But at the end of the day, the president, it seems, can't just go off and completely change the budget and stop the spending that Congress has already authorized. And that's what a lot of the lawsuits we saw filed on Tuesday involved. The case that ultimately froze this spending freeze was filed by nonprofit organizations. But as you mentioned earlier, Peter, Illinois Attorney General Kwame Raoul, as well as 20 plus other Democratic attorney generals, also filed lawsuits on Tuesday seeking the exact same thing, because they believe that the Constitution is quite clear that only Congress can pause or change spending. The president can't just do that through a memo issued by his management office.
Okay, so later in February, Governor Pritzker will go before a joint session of the General Assembly and deliver his budget address for his spending plan for the next fiscal year. That spending plan is going to be reliant in large part on the flow of federal dollars, as it is every year, like we just talked about. It's tens of billions of dollars that flow into the state. How nervous do you think people in state government are right now? I mean, has this kind of traumatized them or, shaken their confidence in the essential rules that everybody thought we were all playing by?
Yeah, I think they're extremely nervous. And the governor made that pretty clear in a couple different news conferences he held this week. One of the big questions going into the budget address is, how do you plan a state budget when you have no idea how much money is going to be coming in from the federal government? And federal funding makes up a huge portion of state government funding. So if all of it, for example, were to disappear like it appeared for a few hours on Tuesday, what's going to happen, that would force major cuts across the board in state government, and very important services wouldn't be covered. So the question for the governor going into his budget address in a few weeks is really, how is he going to plan for a number of federal funding that he really has no idea what it's going to be? Because as we saw this week, it could certainly change within the next few weeks. Just in the month of February, we don't know how much the federal government's even going to be giving us now through the end of the current fiscal year, let alone all of fiscal year 2026 coming up. So that's a huge challenge that he needs to think about. And what he said in response to one of my questions at a news conference on Thursday was that basically he's coming up with contingency plans. They're approaching this as in there's going to be some sort of federal funding there available, because a lot of these programs have been in place for decades, but they're trying to plan what's going to happen if something all of a sudden disappeared. And the big example he gave is Medicaid spending, which Illinois receives about half of the Medicaid spending from the federal government. The federal government reimburses the state for a lot of those expenses. And if all of a sudden that were to stop, then the state would essentially be on the hook for covering people's health care. And that's billions of dollars that the state just simply doesn't have, and is going to be next to impossible to come up with no matter what they do on the revenue side.
That's right. I remember him saying that Medicaid, it's the joint state and federal health insurance program for low-income people and the disabled, and many elderly people as well. It covers about a little more than 3.5 million people in Illinois. It pays for a large percentage of all childbirths that occur in Illinois. And as you say, the federal government's paying just a little more than half of it. And I think what I remember the governor saying that if we don't get federal funding, if the federal funding is cut off, we can't run that program on our own. The numbers are just too astronomical for the state to take care of. So yeah, there is a lot at stake in the flow of federal dollars into the state of Illinois and into all other state coffers. That's something we'll definitely continue to cover as the state legislative session continues. Ben, thanks for being here.
Thanks, Peter.
In other news this week, the long-running federal corruption trial of former Illinois House Speaker Michael Madigan is now in the hands of the jury. Capital News Illinois' Hannah Meisel has been covering the trial since it began back in October. She's with us here today. Hannah, welcome back.
Thanks for having me, Peter.
So, for the better part of 40 years, the name Michael Madigan was synonymous with Illinois politics. He was kind of the embodiment of political power. And in the eyes of many, he also embodied a certain political style that a lot of people considered inherently corrupt. And certainly federal prosecutors thought it was inherently corrupt because he was brought up on multiple charges of corruption. Why don't you remind us, what are the basic elements of this case? What are federal prosecutors charging him with?
Yeah, Madigan has been charged with 23 counts, ranging from an overarching racketeering charge that says he and his co-defendant, longtime Springfield lobbyist Mike McLean, ran basically a criminal enterprise together that sought to enhance and preserve Madigan's power, along with enriching, themselves and their allies. And in addition to that, Madigan and McLean are both charged with some counts of bribery. These counts, as it pertains to Madigan, allege that he, sought and accepted bribes in the form of jobs and contracts for some of his political allies at public, electric utility ComEd, and also telecom utility AT&T Illinois. And then in addition to those charges, Madigan and McLean on some counts are charged with bribery, and Madigan himself of extortion when it relates to Madigan's private law firm that he founded in the late 60s or early 70s with his law school buddy. And the two of them eventually focused on property tax appeals. And, just by the nature of Madigan's very public profile and getting to know so many, kind of powerful people, on the witness stand, Madigan's former law firm partner basically acknowledged that Madigan was, as the prosecutor put it, the rainmaker for the firm and brought in a lot of clients. And so Madigan is charged with using his official office in the office of Chicago Alderman Danny Solis, who was an FBI mole unbeknownst to Madigan, using both of those offices and abusing them, in a way that brought in business for his firm, allegedly.
Okay, and you wrote extensively about the wiretaps and the secret recordings that Danny Solis was able to make for the feds. And for those who knew about Michael Madigan, he very famously did not own a cell phone. He did not have an email account. He didn't use any of the modern kinds of electronic communication, either because he was just sort of old-fashioned and stuck in his ways, or because he knew how easy it was to monitor or tap those kinds of communications. So how surprising was it that there were all of these recordings of him, of a man that famously tried to avoid ever being recorded, and how damaging was that evidence against him?
Sure. We've now known about Danny Solis and his cooperation with the FBI we just passed the 6-year mark of knowing that, Danny Solis was cooperating and then making these recordings against Ed Burke and, eventually we found out Mike Madigan. And Madigan was also captured on wiretap with his co-defendant, Mike McLean, extensively, because McLean's phone was tapped for, I want to say, a total of 9 months over like a 1.5 year period or something like that. The two of them talked all of the time. Just nothing, I would say, would stick in the jurors' minds more than some of those key wiretap recordings and, some of these secret videos that Solis made of Madigan, because of the way that your brain encodes information, and also just the length of this trial. It's been so long. The jury heard from 65 witnesses, saw thousands of documents. But again, in closing arguments, the feds and the defense attorneys kept, coming back to these key moments in those recordings because, they know that those are some of the most effective things that a jury is going to talk about.
Okay, so I'm thinking back to the summer of 2020 It was just earth-shattering news that Commonwealth Edison had entered a deferred prosecution agreement. They admitted to this years-long scheme of bribing the former speaker, and who was still the speaker at the time, and agreed to pay a $200 million fine. Year and a half later, AT&T of Illinois enters its own deferred prosecution agreement, pays a $23 million fine. I mean, it seems like those deferred prosecution agreements have to weigh kind of heavily on jurors' minds, even if it wasn't brought up in the trial. Everybody knows about them. Is there kind of a presumption that there must be something to this case? Did the defense have a high bar to cross to show to punch holes or cast doubt on the case?
Well, I would say that you're right about, the fact that these deferred prosecution agreements, these are huge amounts of money. The companies, obviously they wanted to pay them so they wouldn't have to be dragged any further. But I will say that during jury selection, each juror was questioned, the folks who were not, automatically disqualified by their answers on questionnaires. And most of them knew next to nothing about this. Maybe they had heard about ComEd in the news. Maybe they were kind of aware that there was some sort of trial at some point. I don't know that they were, aware of these fines that they paid. And it was actually not brought up in trial. You're right about that. But, I think in jurors' minds, also what we learned from jury selection is, most of them inherently kind of distrustful of politics. Of this business of lobbying. We heard from some jurors that they thought that lobbying was illegal. And of course, in the last, 3-4 months of this trial, they've learned that lobbying is not illegal, that it's, a very highly regulated industry under the First Amendment. But, it was very interesting to see the defense's closing arguments, especially Madigan's attorney. He really wanted to drive home. He said it multiple times. Do not let the prosecutors, use your inherent suspicion, and use your cynicism about politics to drive your decision making here. I think the jurors, though, what do you ask about? Are there things that cast doubt? Absolutely. This case is not as cut and dry as the ComEd trial, which I also covered in the spring of 2023. Of course, the charges are, that entire episode makes up the bulk of this case, and jurors heard about it for, I think, more than a month, starting in October, November. But there's definitely a lot more. The prosecutors have a higher bar. They have to prove that Madigan, solicited these bribes and that he did so with quote unquote corrupt intent. The U.S. Supreme Court this past summer made a ruling that kind of changed their interpretation of the federal bribery statute under which some of these charges have been filed. And so the defense is trying to use that ruling to their advantage, and they really want jurors to concentrate on whether or not Madigan knew and had quote unquote corrupt intent. But prosecutors have, they tried in their closing arguments and in their rebuttal, of course, they get the last word to say that, of course, Madigan had corrupt intent. Of course, that he wanted to, he was driven by power and profit. And, it's implausible, as Madigan claimed, that he knew nothing. And, they also concentrated, which we can talk a little bit about, on, trying to take his testimony, because he testified in his own defense, which was a big surprise earlier this month, and tried to compare it with what we heard on those wiretap calls and in those secretly recorded meetings to prove that Madigan was lying to the jury on the stand.
Well, it seems like part of this might then come down to the definition of corrupt and what federal prosecutors might consider corrupt, what you and I might consider corrupt. People of a certain age who grew up in a certain area of Chicago might just consider the way things are done is just business as usual, standard operating procedure. I mean, is there kind of a cultural difference here between what some people consider corrupt and what other people might just consider normal operating business?
Yeah, no, I definitely think that the jury is going to be talking about that. What's interesting about last summer's Supreme Court decision is that it relied on this word corrupt when it was trying to define bribery versus gratuity, which is what that case is about. But they didn't bother to define the word corrupt. And, there is a case from, I think it's 2005, had to do with Arthur Anderson. In that case, the court defined the word corrupt a little bit, and but it might be, something that might be re-litigated in the future. But the point is, it is kind of left up a little bit to the jury's interpretation. The most that was landed on in the jury instructions, which the jury can either pay really close attention to or they can ignore. It's totally up to them and their deliberations. I think they're going to have probably a robust debate about what that word means.
Okay, so we should note that even though the testimony and the arguments in court are over, you are still camped out, along with, I imagine, several other reporters, camped out in the federal courthouse in Chicago, waiting for the jury to ask questions and, of course, waiting for the jury to issue a verdict. Just sort of curious, when you talk to other reporters, other people in the courthouse, what are the betting odds or the over-under on how long this is going to take?
Well, we, of course, did make a pool. Everyone's paid in $1, not for the verdict. I want to be very clear on that, but just how long the jurors might take to deliberate. And, based on our knowledge from what's happened in the other Madigan-related trials. I mentioned AT&T in the spring of 2023. Just before this trial actually got started in September, there was a separate AT&T-related trial. And in that trial, the former president CEO of AT&T Illinois, that ended in a mistrial because there was a hung jury after, I think it was like a day and a half, 2 full days of deliberations. AT&T maybe took like 4 or 5 days. I know it was 27 hours. I think that when you spend this amount of time, even though, of course, you're eager to kind of maybe get back to your regular routines, back to your jobs, my goodness, there was one teacher in the pool. Imagine, missing basically your entire first semester and the beginning of your second semester. But they are also very invested. So I think that they're going to go line by line on the indictment and every single one of those 23 charges. And, those jury instructions, like I said, they're free to, follow them to the letter or kind of ignore them and go with, kind of other things. We're never going to know. It's not like it's, everything in that room is secret. But I think that the fact that the jury instructions were brought up again and again in these week-long marathon closing arguments, they're going to go through every line and, they're supposed to check little boxes as to elements under each count. And that deserves a lot of time. I will say that the jury said that they're going to sit on Fridays, which is when we are recording, even though the trial generally there was no Fridays except for one. And, that could indicate that they want to hurry things up or that they're very serious about their deliberations and don't want to forget about things over a longer weekend. And they also said that they're going to leave at 3:00 on Fridays, plural. And, maybe that means something, maybe that doesn't. I'm not sure. But, I think we're in for at least several days of waiting.
Okay, well, we will be waiting with you to hear what the final verdict is. In the meantime, that will do it for this edition of Capital Cast. Capital Cast is a production of Capital News Illinois, a public affairs reporting project of the Illinois Press Foundation, with significant funding from the Robert R. McCormick Foundation. Until next time, this is Peter Hancock on behalf of the entire Capital News Illinois team saying thank you for listening.